Welcome Mr Aaron Lane from the Institute of Public Affairs. I understand information on parliamentary privilege and the protection of witnesses and evidence has already been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear before the committee today?
My name is Aaron Lane and I appear as a legal fellow for the Institute of Public Affairs.
Thank you. I now invite you to make a short opening statement, and at the conclusion of your remarks I'll invite members of the committee to put questions to you. Thank you, Mr Lane.
Thank you, Chairman. Senators, thank you for the opportunity to speak today here at this public hearing on behalf of the Institute of Public Affairs. The IPA has a strong research program in this area. So for the committee's information, I'm an Australian legal practitioner, having been admitted to the Supreme Court of Victoria and registered in the High Court of Australia. I've previously acted for state government clients in enterprise bargaining disputes. I hold an economics degree, an honours degree in law, a graduate diploma of legal practice, a Master of Arts. I'm currently undertaking my PhD in law and economics at RMIT University, where amongst other things I'm researching the impact of enterprise bargaining agreements and what effect they have on innovation in the public sector. The government's workplace bargaining policy is an important tool for the government to provide agency heads with a level of autonomy and flexibility over enterprise bargaining negotiations while retaining an important measure of control. The most general principle that underpins the IPA's submission today is the idea that workplace bargaining is a two-way street. Whether in the private sector or the public sector, bargaining takes negotiation from both the employer's side and the employee's side. And the IPA believes the government's policy provides the flexibility for this to occur on the employer's side. It's true that the policy puts a cap on remuneration increases at 2%, and the IPA considers that it would be economically irresponsible for the government to raise this threshold based on the current debt projections, the current inflation figures, and the risk that above inflation wage growth in the public sector may then spill out over into the private sector. For instance, while the policy provides this overarching cap on remuneration, there is scope within the agreements, within the policy, to increase salary beyond this through packaging of other benefits or through productivity increases. And I think the committee's task in our submission is to question whether this is occurring on the employee side as well. And this comes to the substantive part of the IPA's submission based on the research that we have done. Last year, the IPA published a paper, Driving a Soft Bargaining, examining the Commonwealth Public Sector Enterprise Agreements 2011 to 2014. The authors of this report were myself and James Patterson, then Deputy Executive Director at the IPA. And this research, which we've provided to the committee as part of our submission, gives the committee with examples of the kinds of trade-offs that could be made in these enterprise negotiations at the moment. So, for example, the research shows that the APS agreements start from a higher point compared to private sector averages, and the agreements provide for salary increases each year for individual employees because there is a presumption in the agreements that employees will move through the steps and the bands year on year. All APS agreements contain generous allowances which have the effect of increasing the overall salary by up to tens of thousands of dollars each year. And this is in addition to the generous superannuation entitlement compared to the private sector, the redundancy entitlement, which is up to quadruple what you would find under the national employment standards. In terms of leave entitlements, these also exceed the national employment standards, and there are some particular leave entitlements that you would not see in private sector agreements. Further, we've got evidence of varying degrees of control by public sector unions over the operation of agencies and departments, and quite prescriptive performance management clauses. And this is in addition to the privilege clauses that exist within those agreements, which provide perks to unions and their members. So the IPA submits that there is scope for negotiation, there is scope for bargaining, and that we can't have a situation where the employee side isn't coming to the table as well, without considering some of the trade-offs that could be made in terms of getting salary increases. Again, thank you for the opportunity and the invitation to be here today, and I look forward to your questions.
Senator Patterson, did you want to start by questioning your own research?
That's very kind, Senator Marshall, but given the probably fairly transparent conflict of interest, I'm going to leave my questions. That's not to take undue credit for the work. I assure you the bulk of it was done by Mr Lane, so I'll let him capably answer your questions.
Thank you. Did you want to start then, Senator McKenzie?
Oh, no, I'll follow up from your questions.
Okay. Mr Lane, I take it from your submission that you actually believe that the National Employment Standards should be the benchmark for wages and conditions in the country. Is that a fair assessment? And if I'm wrong, please explain.
Certainly. It's a good question. And I think that question is wider than the question I think that the committee is specifically looking at. I think it's the benchmark that we have at present. I think that the IPA's position would be that it should be up to individual employees and individual employers to come to an agreement about the wages and conditions that they would seek. Some employees might be seeking less of a particular category of leave, for example, and would prefer to have that as additional salary instead. Those sort of bargains cannot happen under the current industrial relations framework. Should they be able to happen? In our view, yes. There should be a bit more flexibility allowed under the current bargaining framework. However, we're dealing within the confines of the system. My understanding is the government have no plans to change the broad parameters of the Fair Work Act. That isn't on the table. If the IPA was to design an industrial relations system, it would give much more flexibility for individuals to make up their own minds about their pay and conditions. But I think that's the appropriate benchmark that we've got at the moment to compare to.
So I think we've seen your industrial relations system in practice before. But you do accept that the National Employment Standards are the worst legal minimums that can be applied to people?
I wouldn't necessarily characterise it as the worst. That is just the minimum. That is the legislated minimum that applies, and that's what we have at the moment. And that's what exists in majority of private sector agreements that I've seen in my sort of experience have been adopting what has been those reflected in the current Act. They are, in my understanding, has been the benchmark for some time.
All right. Well, I think most negotiated agreements actually move beyond the lowest legal minimum, or my words, the worst possible levels. Senator Moore, did you?
It's certainly my understanding, Mr Lane, that in terms of the process that the National Employment Standards are the minimum, and that's across all the conditions of service in Australia, and then industries and agencies are then in the public sector and in the private sector, it's their role then to bargain within that and are able to achieve what they can above that. That's my understanding.
So, certainly.
I just wanted to have that clear in my own mind so I can tick that off.
Yes.
Mr Lane, in your work, and I thank you for it, have you actually quantified all the types of leaves and things that you've put in your paper? I'm wanting to find out, what you're saying is that there is a certain salary amount and you've gone through and looked at a range of conditions, and I understand that's also based on the experience you have with working in state government and so on, so you've got a real knowledge in this space. So have you gone through and quantified those areas in terms of the different types of leave and how much they're worth?
No, this is a qualitative study.
That's-
It's a qualitative paper.
I just wanted to
Yeah.
make sure whether you've done any work of that kind. And also, have you done comparisons between the Australian Public Service and the different agencies there and the states that you said you've done more work in?
This paper is focused on the
federal.
Commonwealth agreements, the methodology. I mean, obviously there are so many agreements that we have to look at. The methodology that was taken in this particular paper was to limit it and make the study manageable. Was to take the top 10 agreements.
The biggies, the big ones.
And take which account for at the time 72.4% of the entire sort of APS employees were covered by those sort of top 10 agreements. So that was the methodology of the paper. It's certainly an area that needs further research.
Absolutely.
I think that's a reasonable methodology is sort of what we were getting at to try and make that workable.
I was just, because of your introduction, I was just wondering whether you had done any work on top of this paper, looking at the work in the state agencies because of the experience you'd listed.
No, it's not something we've looked at the moment.
And there was just one other thing. You may well have heard previous questionings, and I'm asking this to a number of people. We have the situation where we now have agency-based enterprise agreement in the Australian Public Service, and we've had some evidence to say that there could be some argument in favour of having a more centralised process now after the 20 or 30 years experience we've had with agency bargaining. Does your organisation or yourself have any view on that issue?
Senator, it's a good question, and it's something that should be asked and should be looked at. The IPA's approach is that we want to see greater flexibility and a greater ability in this space for government to be able to set pay and conditions that are particular to their specific workforce.
Yep.
Different agencies will have different specialities, they'll have particular tasks, and that's particularly so in the public sector where there might not be a direct equivalent in the private sector. I think the process at the moment is still highly centralised. So I think that's something to keep in mind, that even within the flexibility of the government's policy, the workplace bargaining policy, we're still dealing with a highly centralised wage fixing arrangement that we've got for the Commonwealth public sector. So the starting point is a highly centralised point. Could you move it to an even more centralised point and have something like a wage determination, whether that might be from a tribunal? Yes, you could. You could do that. You could highly centralise it. There would be the arguments in favour of that approach would be that it would be more time efficient, perhaps, in the sense that we'd have one, it'd be like running a case before the Fair Work Commission in terms of the minimum wage case, for example, where submissions are heard and then the Commission would come down with a finding. That might be quicker than in the minds of some people than having a variety of agencies all bargaining all at the same time. I can appreciate the argument there. But what we also need to do is appreciate the costs of that. And the costs of that approach are in the flexibility and the ability for individual agencies to set their own conditions. There might be things that work in one particular agency that don't work in another agency. And if we have uniform pay conditions, etc., throughout the entire public service, you might find that those inefficiencies present themselves in different ways. That might be delays in particular decision makings in terms of conditions. It might be bureaucracy and the costs that are associated with that, or it might be paying particular public servants higher than they would otherwise get had their agency been, in an individual bargaining arrangement. You might have public servants that are paid lower than they might have been if you were in an individual bargaining arrangement. So you sort of, having that averaged out. I appreciate you could centralise it further, and there's an efficiency, in terms of the time and effort that goes into those negotiations, but you would still have to negotiate anyway. That would still be a time-consuming process. There would still be all the parties that are interested in bargaining at the moment would still be trying to make submissions to that determination. So while it would mean that there would be one process, that process would be expanded quite a lot. So I think there are costs and benefits. Again, we would err on the side of giving individual agencies the most flexibility and the most autonomy so that the public service can be managed in the most efficient and effective way, keeping in mind that at the end of the day, government services are paid for by the taxpayer, and the Commonwealth Government and the Commonwealth Parliament have an obligation to make sure that the public service is run in the most cost-efficient and effective manner.
Thank you, Mr. Lane. Just has the IPA done any work on this, or is that just from your personal?
Senator, it's not something we've considered.
Okay, thank you.
Would you say that the public sector also has an obligation to be a good and high-quality employer? Because just coming back to what you said about, the cost effectiveness, efficiency, and I think that's right. But I don't think that should mean, and I just want to clarify your view, that you need to be what might be considered a hard-nosed, ruthless, uncaring employer either. I don't think they're mutually exclusive. I think you should have, a good quality employer that takes the needs of its employees into consideration, and the employees believe that they're being treated well.
I don't think they're mutually exclusive, but I wouldn't look at it in that way, in the sense that there is an economic incentive at play here, which is the demand for labour and the demand to attract high quality candidates for roles in the public sector. And if the government are not seen as a good employer, whether that's from a career perspective, whether that's from a salary perspective, or what have you, then that's going to make those positions less attractive. There are going to be less candidates for those particular roles. So there's already economic incentives that are at play here. So, I mean, in that respect, I think that that's sort of taken care of. In our submission, just sort of to take it back to our submission, the paper details, the higher starting point of public sector salaries and public sector conditions. This is the overarching theme of this paper, is there are a variety of conditions that exist in public sector agreements that would never exist in the private sector. Take the leave provisions, for example, In some agreements, there's you get days off for moving house. Now, I haven't come across an agreement in the private sector where you get leave for those sorts of things. There's provisions for leaving early on Maundy Thursday, or not having to take annual leave between Christmas and New Year, and a variety of other sort of leave arrangements. If we look at personal leave, that is something that is accruing year on year, which you no longer find in private sector agreements. So while there's economic incentives at play here, I think we have to be reminded that we're starting from quite a high point. When the Australian public service agreements would not be categorised as being underpaid or low conditions or anything like that, in my view.
So I've just got one last question. So do you think morale or poor morale, frustration with the bargaining process and potentially leading to a lack of trust between management and its employees when agreements are put up to a vote, voted down, and effectively the same agreements just simply put back up for another vote to be voted down? Do you think, though, that the drop in morale, the frustration with that, the lack of trust, has an impact on efficiency and productivity within the public sector?
Senator, it's not something I've considered. I guess what I would say in response is, what's the underlying cause of that frustration, and is it the government's workplace bargaining policy being too restrictive, or is it the sense that the public sector unions, for example, haven't agreed to a single enterprise bargaining agreement that's been put before employees, and whether the employee side might be holding up the deal.
Sure. Senator Mackenzie.
Thank you. Thank you, Mr Lane, and Senator Patterson for your submission. In another committee I sit on, we explored healthy lifestyle payments as part of some of these unique allowances that are in public service agreements. Can you outline for the committee, do you have any knowledge of those sort of allowances?
Yes, Senator. The three that we've detailed in the report, the three examples that we've pulled out, and these are just three examples, there's certainly more that exist, but the three examples we took that are fairly representative of the sorts of things that are in agreements are for example, so this is on page 11 of our report, and in the Department of Health agreement, you can get $165 for your prescription eyewear. In the Department of Agriculture agreement, you can get flu vaccinations, for example, and also in that agreement, $300 a year for gym or fitness memberships. Now, that's reimbursement of that particular membership, not whether you've actually attended.
Whether you'd actually rocked up to the gym at all.
Correct.
I think Treasury, it's $600 and you don't have to show any receipts, which is unique, particularly for that department.
Yes, some are more, some are less. These are just some of the... That would be a middle of the road figure for these sort of agreements.
Okay, so when we're comparing what seem to be incredibly generous variety and amounts of allowances within public sector agreements that really would not be found in private sector agreements, has the union, to your knowledge, have the unions packaged that up in a way and come to sort of some realistic proposal to government?
Well, that's not my understanding. Sorry, that's not my... I don't have any knowledge about that.
Well, you do go to say, that...
But
sorry, your submission in summary does sort of talk about unions cannot continue to seek additional entitlements without considering trade-offs. So I'm assuming you've done some work around that.
Well, nothing has come to light that has been the case. So obviously I'm not somebody that is sitting in the room, but if that was being proposed, then it would seem likely that that would have been canvassed in, for example, unions' log of claims that some have published, the Australian Public Sector Commission, website, for example, has a variety of information there on the bargaining process at the moment. So it's not taking into account those sort of objective, information that's available. I haven't been able to find any evidence that has been undertaken at the moment, and it's certainly not something that the public sector unions are claiming that is on the table at the moment. If it was, this would be one of the arguments that they would be putting forward as to their reasonableness of their conduct at the moment.
Dr. Williamson and Professor O'Donnell note that the APS has traditionally been a testing ground for the Australian government's workplace relations policies. Would you agree with that statement?
Can you just repeat that? Sorry.
That the APS has traditionally been a testing ground, if you like, for the government's workplace relations policies.
I'm still not sure I quite understand.
Well, they're sort of basically saying that the Australian government road tests broader policy ideas around workplace relations through the APS sort of system. All right, on notice, if you could look at, on notice, just look at Dr. Williamson and Professor O'Donnell's work and just give us your perspective on that. That would be useful. We've also been discussing this morning gender issues and the reduction or claimed impact that some of the negotiations having on the public service as workplace of choice for women. And I'm just wondering if you had sort of any understanding of or any information for us around the entitlements that would assist women in balancing work and life. How is the APS perceived on gendered sort of grounds? I'd appreciate your perspective.
Certainly, Senator. I think something that I can point you to in terms of the IPA's research paper on page 15 is the personal and carers leave provisions. Under the National Employment Standards, it's 10 days a year, and the Table 5 sets out the personal leave that's available under the various different agreements. They range as a minimum the Department of Defence of 15 days up to 20 days, which is obviously double the NES. The other thing to note is that leave entitlement is accrued. So if you've got 20 days in 1 year and you don't take any of those days, the following year you have 40 days. And then 60 days, and so on. In my view, this is a particular provision. I think it's a very generous provisions that exist under the current agreements. So these are under the current agreements.
So after 10 years, effectively, you have a year off. You could potentially have a year off.
That's my understanding.
Right. Any other workplaces outside of the public service that would have that sort of provision after 10 years? That you could accrue leave to ensure that you have your 11th year paid in full?
Not to my knowledge. It's certainly not something I've seen in any private sector agreement.
Okay. Well, thank you for your submission. I think you outline incredibly generous, entitlements and conditions for the public service quite well for the committee. Appreciate your work.
Senator Moore?
Mr Lane, thank you. And picking up from Senator Mackenzie's questions, you've had a look at the provisions. Have you had a look at uptake of them and the cost of them? You said in response to an earlier question that this was a qualitative paper rather than a quantitative one. I'm just wondering whether in any of your work have you actually costed them, these conditions and the way they're used?
As I said previously, Senator, this was a
qualitative
paper,
yes, okay.
And those sorts of departmental take-up rates is not something that the IPA has any visibility over, but I'm sure it's something that the committee would be able to obtain from those relevant departments.
Yes, it's across the range of processes, because you would be well understanding that in some of the evidence we've got, it's around these conditions that people are concerned about how they can be assessed and so on. And flexible working hours, did you have any look at that?
Again, on page 15
I read it.
of
That's
our
it.
report,
Yes.
briefly just mention that all the APS agreements that we've looked at provide for a flex time scheme where employees accrue leave
Yes.
essentially by working more than their normal hours of work, which has the effect of increasing leave. And some departments allow you to cash out that amount, so essentially to top up your salary. The private sector equivalent for the usual conditions around full-time employees is that a reasonable amount of overtime is included in your salary component. So that's again something that's over and above.
So again, no quantification, just a statement of what's in.
Well,
yeah.
yeah.
Okay, thank you.
Right, well, again, thank you.
If there's
Sure.
more time.
Yes, there is.
Yes,
Senator
excellent.
Mackenzie?
Just, you make some comments around union control within the public sector. Could you just briefly run the committee through the highlights, if you like, of that section of your report, section 5?
Certainly. So this is something that is a feature of all the agreements. The state agreements that the IPA has recently looked into. Last month, I released another paper with a colleague on the CFA MFB dispute in Victoria, which also, highlighted these. So it is something in terms of state agreements. It's something that happens as well. It's quite prolific. These clauses are guised as consultation, and I guess provide the union directly with varying levels of control. So, for example, this is detailed on page 22. There's a wide variety of matters that secretaries or agency heads are required to consult with, and it's very, very broad. So where a decision is made to introduce major changes in program, organisation, structure or technology, so it's very, very broad. So these could affect, for example, an agency's ability to make changes about the composition or the operation or the particular skills that might be required in a particular job, or altering hours of work and retraining employees, reallocation, those sorts of things. To give one example, the Australian Tax Office Agreement has a provision where it limits the ability of the tax office to move its employees to a new office, even if that office is within the same city. Yeah. So I'm from Melbourne. If we're talking about moving the office from Collins Street a block away into Burke Street, that would require this whole sort of consultation. It allows the union to hold up that process. It allows also an ability to, if there's a continuing dispute about those arrangements to go off to the Fair Work Commission. It's been more, as I said, the more recent paper that we've published on this gave the example in the MFB of the MFB wanting to introduce a new type of pencil for firefighters to use, and this was the subject of a Fair Work Commission hearing because the union took that to the Fair Work Commission had a dispute about it. So although it may seem that consulting is the thing to do, what these provisions are really guised as control provisions. They're much more than consultation.
I think those this committee did do the inquiry into the CFA EBA as well, which highlighted those issues. We've gone through a lot of provisions. There's one. Yes, this is the last question. I think we get participation in major sporting events. If you've got a netball team in your department and you're going to the Masters Games, you'll get paid leave to do that, is my understanding. In your opinion, Mr. Lane, would this pass the pub test with most Australian workers not in the public service?
I don't think so, Senator. I think that these sorts of entitlements would be considered overly generous, and I must admit, when doing this paper, I was surprised to the extent of some of these leave provisions. Moving house, for example, was the classic one. The Department of Defence have what's called Defence Day, where you get to take a day off, no reason, nothing required. It's not part of your annual leave. It's not part of your sick leave. It's not part of your personal leave. It's you just take a day off when you sort of feel like it.
It is quite surprising when you drill down to the detail of the generous nature of these agreements. Thank you, Mr. Lane.
Yes, thank you, Mr. Lane. We are out of time, but I am relieved to know that you're in the pub with Australian workers testing some of these theories out. So
Yes, I dare you to do that, Senator Marshall. I dare you to do that.
As we all
thank you, Mr. Lane, for your submission and your presentation to us today.